Hi. So today I'm going to share with you about the properties that come to a female Hindu if she dies without writing any will. So in the legal language it is called intestate death. If a female Hindu dies without writing any will deed, if she is married, then the properties that are in her name, whether acquired by way of Sridhana, acquired by way of partition, acquired by way of purchase, acquired by way of her skill or hard work or any other form. First of all, any property of a female Hindu is her absolute property. Unlike prior to 1956, before the Hindu Succession Act came into force, she had a limited right to enjoy the property till her death. But after 1956, she has absolute right on the property. So the property can come to her in many forms. It can be by way of even maintenance also or accrued maintenance also. Property can come to a female Hindu and it is her absolute property. She can deal with that property in whatever way she wants. Now if she dies, how the property devolves into her heirs is what I am going to share with you right now. First and the foremost shares will be to the children of the female Hindu and husband. If she has two boys and two girls and husband, then there will be 1/5 share for each. Imagine one boy died and he has a son of a predeceased son or a predeceased daughter. That means children died before the death of a female Hindu. In those instances also, the children of the predeceased son or a daughter will get the share, equal share. Now this is the first category. The second category is the heirs of the husband. If nobody, no children are there, no daughters are there, sons or daughters of a predeceased son or a daughters are there, husband is not there, then the property goes to the heirs of the husband. If heirs of the husband are also not available, that is the second category, then it goes to the mother and father. Now if mother and father are also not available, then it goes to the heirs of the father. If heirs of the father are also not available, then it goes to the heirs of the mother. So this is the schedule. This is the line. First it goes to the children or grandchildren if the children died before the death of the female Hindu and husband. So this is one category. The second is heirs of the husband. The third is mother and father. The fourth is heirs of the father. The fifth is heirs of the mother. Hope I am clear. Now if the female Hindu inherits the property from the mother and father and she dies, this is an exception. Then it goes to the heirs of the father. And if she inherits the property from husband or father-in-law, then it goes to the heirs of the husband. So adequate precaution has been taken in the Hindu Succession Act pertaining to the devolution of property, movable and immovable, of a female Hindu to see that the property goes back to the source. So at least it is going to the source, not to the any other third party. So this is the precaution that is taken. And recent judgment of the Honorable Supreme Court, I will just briefly illustrate that judgment. There are two brothers. One brother died before 1956. Another brother died before the death of that brother. So A and B are two brothers. A died in 1949. B died before 1949. So before the death of A, B died. A has one daughter. B has 5 children, 4 daughters and 1 son. And A acquired a property, self-acquired property in 1935, 10 years before his death. So now it was a self-acquired property. Now self-acquired property will not be treated as ancestral property or a co-parcenary property. It will be given to the heirs, as I described earlier. So the property came to the daughter of A. A has a single daughter, the daughter of A. So the daughter of A died after 1956. So now, as per the schedule I explained earlier, the courts below decided that the share of the daughter of A, who is the owner of the self-acquired property, goes to the male member who is the son of B. Now Supreme Court said that it cannot be done. It goes to even the daughters of B. So they claimed for 1/5 share and they got the 1/5 share. So here the self-acquired property of a female Hindu. Now carefully understand the wording here. The self-acquired property of a male which came to a female Hindu, which is her absolute property, and if she is not available, it goes to the heirs of father. So who is the heirs of the father? Because she has no husband. The daughter of A doesn't have any children or husband. Then it goes to the heirs of the father. So that's how that exception, based on that exception, it went to the heirs of the father, who is none other than B here, who has 5 children, 1 son and 4 daughters, and they got 1/5 share. So here the female Hindu's property devolves in this way. Even though it is self-acquired property, even though it is ancestral property, once it is her property, it is absolutely her property. So female Hindu gets share even in the self-acquired property of her father. This is the sum and substance and the principle that is once again reiterated by the Honorable Supreme Court in a recent judgment, which is in the description box. Kindly go through it. Thank you. Thanks for watching. If you have any doubts, kindly comment.